Good morning, everybody. I'll call our meeting to order. I believe all of the members that are going to be here are here, and we have a couple of witnesses this morning, including one that's going to be testifying by telephone due to her disability. She's unable to attend in person, so we're going to make an attempt to accommodate her testimony by phone. I do have a rather lengthy opening statement that I'd like to make, and then I'll allow the other two members that are here to make whichever statements they would like to make. And then we will start with, well, my agenda says Kim Belshea and John Wagner, but they are not here today. But we will start with the department. This morning we're returning to discuss the implementation of recent IHSS program changes and follow up to the hearing that we held last week. Last week we held a hearing to discuss the potential impacts from DSS's incomplete guidance and implementation of the changes that these would have upon California's 460,000 vulnerable consumers. At our last hearing, the director of DSS suggested that a statutory time constraint was responsible for the rush process that DSS was using, and since that time we've unsuccessfully attempted to address that problem in cleanup legislation in SB 69. SB 69, as you know, was killed in the Senate by the Senate Republicans on Tuesday after the DSS sent its opposition letter. And I want to talk a little bit more about that later, but right now I want to focus on the problems that actual real consumers are facing due to the changes that were made on Monday, this Monday, the first business day after the November 1 implementation date. Throughout the week, we've been hearing from consumers, counties, medical providers, and hospitals about the unintended consequences of the unsuccessful implementation of the two budget bills, which have my name on them, AB X44 and AB X419. I'll just give you two specific examples. In San Luis Obispo County, a woman just returned home from the hospital, and she doesn't have a caretaker in place. She's a recent double amputee. She has an infection in what is left of one of her legs. She's unable to perform many tasks without assistance due to the amputation she's endured. She's not yet 65 years old, so she's unable to access many of the local senior resources, such as senior nutrition. And the County of San Luis Obispo is scrambling to find an existing provider because it can't set up a new provider to take care of her in her home. In Santa Cruz County, an 85-year-old woman who lives alone became ill with pneumonia, which, as you know, is very dangerous for an 85-year-old. Her regular provider was afraid that the woman had H1N1 flu, and so she was afraid to work for her while the woman was ill. And among this recipient's health conditions, she has a stroke with a left side weakness, painful spasms to her face, osteoarthritis, and osteoporosis. She is authorized for 85 hours a month of domestic personal care services, and ordinarily she could find a temporary provider on her own or request short-term care through the registry. But due to all the confusion regarding provider enrollment criteria, including what is required of current providers who accept jobs with new recipients, which in my opinion is not how the new rules were supposed to be implemented, it's unclear whether or not a registry referral would be successful for her short-term services that she needs, and the recipient ended up being hospitalized again. So these situations will become more and more common as the pool of available existing providers dwindles and the number of people needing personal care assistance continues to increase, which it has historically. And I don't believe I'm exaggerating when I say that some individuals will be facing real life or death situations as a result of a bureaucratic snafu, and that is simply intolerable in the state of California. I intended to ask the Department of Social Services how their final guidance to the counties, which was issued last Saturday night at 10:21 p.m., Saturday, a weekend, before the Monday implementation. How situations like the ones I just discussed would be handled. I thought that by using concrete examples, I'd be able to focus the discussion on fixing these problems. I also felt that continuing to apply public pressure would create the urgency and attention needed to solve the problems faced by these very real consumers before there were more victims of poor planning. However, as you can see, we are not being joined today by the Secretary of Health and Human Services, Kim Belshea, nor the Director of Social Services, John Wagner. I invited both individuals to today's hearing as of last week, but as you can see, they've declined our invitation. I believe they did send Patricia Houston to join us to read a letter that was written, but not signed apparently, by the director. I will allow her to do so after my opening statement, but I have seen the letter ahead of time, and I want to note that the letter says DSS is focusing on the beneficiaries that might experience difficulty getting their chosen provider enrolled, and that would have been the principal topic for our discussion today. But the letter lacks much in specifics regarding how the focus is taking place, leaving me with many questions which I apparently won't get answered today. As I said earlier, this is unacceptable. Real people have real health needs, and they are entitled to these services, but they're being denied because of an artificial bureaucratic deadline. That brings me to SB 69. This is the bill we put together in less than a week to try to fix the problems. The bill is less than 2 pages long, and it did only one thing. It required DSS to take more time to implement a handful of IHSS provisions that were subject to the November 1 deadline. The bill was inspired by comments made by the director at last week's hearing and was patterned upon the traditional stakeholder process that usually is used by DSS to implement big policy changes. There was nothing new or extraordinary about this. On Tuesday, the department sent us a strongly worded letter of opposition to the bill. There was another letter printed, I believe, in the Capitol Weekly of opposition, and that was the very first feedback we had received from the administration. As I stated in our hearing last week, we are interested in running legislation to eliminate legislative barriers that prevented DSS from effectively implementing the changes that were adopted in the budget. DSS didn't give us feedback until the bill had already passed the Assembly 68-0. No votes. Very strong bipartisan support. And unfortunately, that lack of communication continues today. I would again ask DSS if it needs statutory change in order to successfully implement the provisions on November 1, and I hope that I'll receive a response in some form that doesn't require me to go back to the legislative process to continue the discussion. But from the very beginning, the administration is not engaged in an open discussion regarding the problems we've identified. The tone of communications has been defensive and dismissive, as if this really isn't a problem and everything is working just fine, and we know that it's not. And we've been opposed by the administration at every turn in our attempts to fix this problem. And there are no secrets in this building. We know that the administration worked with the Senate Republicans to kill the bill. And it's unfortunate because it indicates that the administration is not going to cooperate with the legislature in solving this problem that is hurting our citizens. And I know I've been publicly skeptical about the underlying policy of the bill, but this is not an effort to relitigate that policy. Fresno, which is the county that produced the IHSS anti-fraud orientation video, Butte, Kern, and San Bernardino, counties that supported the policy changes, they supported the new changes. These counties are identifying the same problems and getting the same lack of response from the administration as all the other counties are. The empty chairs before us today are a good reflection of the administration that has refused feedback from the very beginning. I don't think DSS needed SB 69 to slip back the implementation dates for the chaos that's being caused. We have identified a list of 12 bills that have enacted major policy changes at DSS over the last 6 years, where the implementation date specified in the ACL was much later than the prescribed statutory guidelines. This is not an unusual situation. For example, we passed legislation that required DSS to implement direct deposit check authority for IHS providers on July 12, 2006, and the department made this provision effective for counties on March 27, 2007, 20 months later. So the question has to be asked, why is DSS so tightly bound by these statutory deadlines in the case of these recent changes? It seems like a choice that the administration has made for some unknown reasons rather than acting as a legal barrier. This is a very unusual situation. In various communications from the department, they suggest that I'm exaggerating the problem, but clearly I'm not. This is coming from numerous counties around the state, and our office is getting firsthand information regarding the impact of these provisions on people across the state of California, and I am simply not going to turn my back on these vulnerable clients who need these services for their survival. And I think it's clear that other legislators here are not going to do that either. To me, it sounds like the department is not taking the human consequences of their work seriously. And by not being here today to address the issues, they're only reinforcing my fear that they don't care if this poor work results in suffering or even death. So until this problem is resolved, I will keep pressing every avenue available to me to ensure that we get it resolved. My name, as budget chair, was associated with creating the problem, and I intend to make sure I get it fixed. So the message that the administration is trying to send me today by not attending this hearing is that they do not intend to cooperate. But I want to make sure they get my message. I am not going away. This is a real problem, and we must solve it. You cannot hide from accountability for this failure of governance, and we, the legislature, will not hide from it either, nor will we allow you to do so. It's not unreasonable to work towards ensuring the IHSS changes we agreed to adopt at the request of the administration are implemented clearly, fairly, and successfully. There's real pain, suffering, fear, and even potential death as a consequence of this failure, and we need to figure out a way to make this work, or the state will be responsible and liable for avoidable pain and suffering. So that's where I am at this point, and I just want to make it really clear, I'm not going to let this issue drop. I know we can run out the clock for the next year, but God willing, I'm still going to be here, and I'm still going to be working on this problem if we don't get it resolved by then. Mr. Chesborough?
Yes, Madam Chair, I want to just thank you for stepping up and using your position as our budget chair to highlight the crisis, the full-blown crisis that has begun, and now is fully underway, and for your efforts. And I'd like to say that we are in a full-blown crisis, and the administration's efforts to kill the attempt to solve this problem legislatively, and the failure to show up today and explain what the administration is doing at the highest levels, it means that the administration owns this. They own this crisis, and as a result, we need to demand that they put before us the steps that they're going to take immediately to alleviate this crisis. Tens of thousands of people across the state are vulnerable. I think we're going to see not only a tremendous humanitarian crisis, but we're also going to see an immediate budget crisis when nursing homes and hospitals become unable to discharge people to go home because they can't go home and have the resources to be safely at home without the personal and medical supports to make them successful at home. And that raises legal vulnerability questions under the Olmstead ruling. And I frankly think the advocacy community in this state has been quite patient in not challenging this state in implementing Olmstead. And those of you who don't know, I think you all do, so pardon me if I'm talking too much about this, but Olmstead basically said that if you're a person with physical limitations or a disability, you have the right to live in your home and have the supports necessary to support you living independently. And we have not implemented that U.S. Supreme Court ruling in this state. The advocacy community has been patient, and as long as we were making progress, but now we're not only sliding backwards, we're plunging backwards into the abyss in terms of the ability of our citizens, elderly and disabled, to have the independent living that Supreme Court ruling granted them the right to. So I quite frankly think that in addition to the humanitarian crisis, the budget crisis, I think we're heading into a legal crisis akin to what's gone on with the prison system. If we want to turn over our ability to control our costs in social services, there's no better way than to directly violate a ruling of the United States Supreme Court. So I think that all the steps we've seen to supposedly curtail costs in IHSS, in fact, are steps of great irresponsibility. And I, again, want to praise you and thank you, Madam Chair, for taking this on. I think we as a legislature have an obligation to shine the bright light of day on it, and that's what we're here for, but you're leading the charge, and I really appreciate it.
Mr. Swanson.
Thank you. Madam Chair, thank you again. I join my colleague, Mr. Chesborough, in his comments, commending you for keeping the spotlight on this particular issue at this time, and will join you at any point this year when there's a need for additional hearings. And I agree with you that this should not go away. I continue to believe that even though the state faces a structural budget deficit, and it's projected that we may face a $7 billion deficit next year, that this is just not a program that should be cut, because in the long run, I'm convinced that it not only provides humanitarian service and necessary service for those that need it, but I also think it saves the state money in the long run. And I think any proper analysis of this, of the services provided by in-home service care workers, would have to conclude that in the long run, the state saves money. My hope is that we request at some point an audit of this decision that has been made and its financial impact, because I think that if we trace the services that have been restricted, we will find that the state actually, by cutting, is costing the state more money. And I think that's important because as we go forward, we need to exempt this line item from these kind of cuts because they provide so much benefit. In the meantime, I think that this focus on the implementation of current law is extremely important for us to make sure that it's done competently in a humane way that guarantees the delivery of services. And we as a legislature should continue to look at cleanup legislation that recognizes mistakes. We need the county and the providers to help us understand the impact so that we can make informed decisions. So I thank you again, Madam Chair, for this hearing and keeping a spotlight on a very critical issue at a very critical time for those in need. Thank you.
Thank you, Mr. Swanson. Okay, since we don't have the director and the secretary here, I believe they sent Patty Houston to come testify. So if you could come forward, I know you have a statement to read.
Good morning, Madam Chair and members. Patty Houston with the Department of Social Services. I'm the Deputy Director for Legislation. Both Secretary Belcher and Director Wagner regrettably couldn't be here today due to scheduling conflicts, but we delivered yesterday, and I have distributed to you today just now, and for members of the audience as well, there are extra copies available. A letter that will serve from Director Wagner, which he didn't sign personally, but he did review from the road yesterday before it was signed by our Chief Deputy Director. This will serve as the department's written testimony today. I can read that to you if you wish, or I can highlight the contents briefly for you.
Why don't you highlight it? Because
Okay.
we have written copies.
Okay. As Director Wagner and Deputy Director Lopez testified last week, we are working to implement the reforms contained in AB 4 and AB 19. We are working as quickly and as efficiently as possible with our county partners and others. We want to acknowledge again that the timeframes are very, very tight as they were passed by the legislature and signed by the governor. The department is just as interested as everyone else in this room and as you members are, and committed to ensuring the ability of vulnerable, elderly, and disabled individuals to remain safely in their own homes. This is the core mission of the Department of Social Services, and we don't take these jobs and stay in these jobs to harm people. Like any complicated program implementation, this has been a challenge, as you know. You can see from the first attachment to our letter that there have been the one entitled AB 4 implementation. that we've issued 24 and actually 25 as of yesterday communications to counties, public authorities, consumers, providers, and stakeholders. Just looking at that two-page attachment to the letter, you know, if you go to page 2, it's in chronological order. The first one was released on September 5th, and we started releasing these drafts back in August. So since the bill was signed on July 24th or 5th or 6th, whatever the date was, we have been working nonstop hours, weekends, furlough Fridays, as hard as we possibly can to meet the November 1st timeframe set forth. At last week's hearing, you also suggested that we submit written responses to the concerns and questions raised on the agenda background materials. We've done that, and they're attached to the letter as the second attachment that you have in front of you. So just briefly in response to some of your opening statements, we've considered and have responded quickly and will continue to do that in clarifying instructions and continuing to issue instructions to counties and others to implement these important IHSS reforms that, again, were put in place quickly, and we are especially bound to the statutory deadlines due to the gravity of the general fund situation that we found ourselves in this year and that we're going to continue to be in next year. So with that, I will turn to you for questions, please.
Thanks. I appreciate your courage in opening yourself to questions because it's difficult without having the director and the secretary here.
It is, and then we don't even have program experts here today because Olmstead Advisory Committee is today.
Which is very ironic.
So they're there.
Yeah, I understand that. We could have obviously worked with the scheduling had we known in advance that this was a problem, and I understand this is a regularly scheduled meeting, so it didn't take anyone by surprise. So it's a little discouraging to not have even been told that, you know, we could find an alternative date. And I appreciate your position in being here, and I appreciate your attendance here. My main question is, well, twofold. One is. I realize the department has been working hard. The problem is that the counties have not been given the guidance and the resources necessary to do the work they had to do in order to get this implemented by November 1. And so the two questions I have are, why did the department not follow its standard process in working with the counties to get this implemented, regardless of the implementation date? Because we know under many other instances, DSS has done that and has actually blown through one of the deadlines that was set in statute in this particular case. So we find ourselves in a very unusual situation, and I think there's not only fear and suffering going on in the consumer community, there's a lot of angst amongst the counties because this is not the way things have normally been handled, and it does not bode well for going forward because we fear that this is the way things will happen now. And there's been a breakdown of communications. And that's one thing I'd like you to address. The second one is I had asked the director last week what he was going to do on November 1 when the computer system has been set up to no longer pay providers. And I would like to know what, if anything, has happened about resolving that issue.
Okay. Well, between the signing of the bill and November 1st, you know, there was a very short period of time. And so that's why the stakeholder process has not worked in the way that you're so accustomed to it working and the advocates are so accustomed to it working. I think Department of Social Services prides itself in the history of working with stakeholders, and many, many stakeholder meetings go into implementing complicated legislation such as Quality Assurance Initiative. Over 30, I think 38 stakeholder meetings went into that over a 2-year process. This legislation did not afford us that time. We didn't have the luxury of time. We got draft documents out as quickly as we could and considered comments that were sent in response to them and have continued to clarify as we go.
I appreciate that. It's I kind of feel like the administration's been, the department has been caught in the middle because this was a date that the administration had requested specifically. And so I realized that the department could have taken a position on that one way or the
Right.
other. I don't know what the internal discussions were, but I appreciate your answer. And then what was done on November 1, if anything, to address the problem of not reimbursing providers?
Well, and I can probably only answer, I'll be taking back questions and getting, complete responses for you very quickly. But on November 1st, the county workers had a new screen on their CMIP system, Case Management Planning and Information Payrolling System, something like that. CMIPS. It's the screen that comes up for county workers. So they have electronic bulletin board. This is a way we communicate directly with the workers, that bulletins pop up and provide step-by-step instructions. I know one of those has been put up this week. And it's my understanding, though, that the population of providers that are affected on November 1st are the brand new providers not known to the system at all. So, we've got 400,000 providers already known to the system, and then every month there's, quite a bit of turnover in the IHSS provider population. But the people that were affected were the providers that are brand new to the system.
All right. What I'm about to say is not directed at you, and I hope you don't take it that way. It's directed to the director and the secretary. I appreciate your offer to get back to us with answers, but this is a public legislative oversight hearing, and it is simply inappropriate for the administration not to send the appropriate people to answer our questions. And I take my responsibility as a legislator to perform oversight very, very seriously. And I would have hoped that the department and the administration took that responsibility also seriously, because it is a responsibility we have to the public, not to ourselves. And while I appreciate your offer to come back with information, this was the time to have the information directly from the director and the secretary. And again, I appreciate your trying to answer the questions that we have. So that's not directed at you, it's directed at them.
Yeah, understood. And we will respond in writing as quickly as possible, and it'll be quick.
Mr. Chesborough, questions?
Yes. You mentioned communicating with IHSS providers through computer bulletins. Do you have any sense of how many IHSS providers actually have computers?
No, communicating with IHSS workers in the counties.
Oh, in the counties. Okay.
About new providers.
Okay. Secondly, what is the department doing to work with the counties to monitor how many recipients are slipping through the cracks and unable to receive services, first? And secondly, how many have had to be retained at a hospital or a nursing home and unable to go home as a result of being unable to obtain services? How many have had to be institutionalized because of a loss of services? Those are all three very, very important pieces of information, and I'd just like to know what steps the department is taking to mitigate that.
Since November 2nd, which was Monday when the changes went into effect, we have been monitoring and will be monitoring. I'm not sure of the level of communication. I know that there's been at least one meeting with the long-term care subcommittee of the CWDA this week. But I know that
people are without services now, today, and so, I guess my questions go to what. Not are we going to have meetings to discuss what we're going to do? What is the department doing now to monitor who's losing services and to try to make sure that does not take place? Right.
If we're not monitoring, I'm sure we will be monitoring. This is Thursday of week 1 of implementation.
Thursday of week 1 that there are people out there who don't have services.
Right. Well, we are listening. We are listening, and we, if a new recipient comes into the program, that's how the providers come into the program. The providers are needed when there's a recipient who needs them. So a new recipient who came in on Monday would be going through an enrollment process anyway. They would be choosing a provider and filling out all the forms, and it takes a while to do that. So, the process, we've heard that many counties are seeing seeing new recipients who are asking for providers, and it's a process that takes time anyway.
Does the administration or the department have a legal process for reviewing the implementation of the program of IHSS through the filter of Olmstead? In other words, trying to determine what actions are being taken that might make the state more vulnerable to being sued for not complying with the United States Supreme Court ruling?
I'm not certain about a legal filter. There probably is, since it was a Supreme Court case, but I know that different topics come before the Olmstead Committee on an as-needed basis. So I'll ask about that.
The October 5th letter that was sent out to IHSS program managers and county welfare directors says that effective November 1st, if you decide to have someone provide service, this is to recipients, I'm sorry, I'm not sure which letter, it was not the letter to counties, it was a letter to recipients. If you decide to have someone provide services for you who is not an IHSS provider before October 31st, that person must complete the 4 enrollment steps and be approved by the county or public authority before they can receive payment from the IHSS program for providing services. If you choose to receive services from someone who's not gone through the approval process, you will have to pay for any services you get from that person with your own money. Last week, it was said to the committee that the department would make allowances. And so the question is, what has the department done to clear up this confusion and update recipients about how those allowances might work to help take care of folks who may not have the resources or may be afraid that they won't be able to be reimbursed for those services? So the question is what have we done to clear up that confusion about whether or not the recipients will be on the hook personally, or whether or not there will be a methodology for them to be reimbursed?
I'm not sure if a clarification has gone out about that. I know that the department has been working with counties on whether certain clarifications should go out, and and at what point in time that should occur.
Well, again, the confusion is now. So,
well, the issue of whether a provider will ultimately get paid, that is similar to how it is in the CalWORKs subsidized child care program today. A subsidized child care provider in the CalWORKs program cannot get paid until and unless they've been cleared by Department of Justice. And a CalWORKs recipient who goes into the welfare department and says, I have a provider, I want to provide child care, the county instructs that person, or alerts the CalWORKs recipient today that they need to get criminal background check, and if they don't pass, they will not get paid. So it's similar to the same situation that's happening.
Except in that case, there's some clarity about what the procedures are and what the possibilities are, and there's not clarity in this situation. And there obviously needs to be clarity.
There will be clarity. We've been working very hard to provide clarity as issues become as we become aware of issues.
And last week, John Wagner testified the department was unable to move the implementation date without legislative authority. On August 19th, I'm told he successfully moved the implementation of the functionality index implementation from September 1st to November 1st. So why is this implementation deadline different?
I'll have to get back to you with that one.
Okay. Thank you, Madam Chair.
Thank you. When the department finds a statutory impediment to doing their job, what's the normal process? Is there a memo, and then it goes where? And
I'm sorry, did you say when a worker
no, the department.
When the department finds difficulty doing its job?
Yes, based on your statement was when you opened up, you said we do not take these jobs or stay in these jobs to harm people. So the assumption is that if there are statutory decisions made that impede the effort to help people, there must be some process the department uses to communicate that.
Well, there's a deliberative process that we use, that within the administration to discuss implementation issues and so forth.
Okay.
I mean,
So-
but what I was saying, Assemblymember, is that we share your goals. We're here to implement this in the best possible way that we can, given the budget crisis.
Sure.
You know, we can't delay indefinitely. We're going to find ourselves in a worse situation come January.
Well, you answered my question. You said that you communicate internally when you find
Sure,
impediments.
it's our job to communicate everything
Okay.
internally.
So with this situation, has such communications taken place? Have you, as a department, communicated internally what they see as serious impediments that in fact may harm the recipients?
Well, I guess I can't speak to a serious impediment that we think may harm people. We've been working to implement effective November 1st. We have 25 instructions on the street. We've
You can't speak to it, or you have not identified any impediments that's going to harm people, which is the case?
you know what? It's not knowledge that I would have. I would need to get back to you to see if anything
get
like
back
that
to
has been identified.
And what about, and could you, just make a note of that and
Yep.
get back to us?
Yes.
So can you explain, since the program has been in effect, can you explain to us any examples, specific examples of adverse impacts that have occurred specifically as a result of this quick implementation?
I personally am aware of the ones that I heard about this morning, and that
I don't know.
our county partners will
What are
be
we talking about?
talking about.
Which ones are we talking about? What are we talking about?
The ones that the chair opened her remarks with about the woman in San Luis Obispo and the woman in Santa
Okay.
Cruz.
No, I'm just talking about you. I'm talking about the department now. And these questions you're the department representative. So these questions are directed at you as a department representative, however they prepared you to come to this
Yeah.
hearing. And the question is, are there specific examples, given the purpose of the hearing, are you prepared to communicate to us any specific examples of adverse impacts that have occurred as a result of the timing and implementation of this statute?
I personally am not aware of any, and I
And-
don't know that any have come to the attention of the department.
I see. So, is the department planning any ongoing meetings with stakeholders to try to quickly understand and work out these questions of adverse impact? Is there anything in the works? Have you talked about that at all? Or?
November 1st having come and gone, I think that our stakeholder process will get back into more of the process that you're accustomed to seeing as we go for implementation dates that are in April and June.
Okay.
And we continue to be interested in hearing about implementation issues so that we can clarify and resolve them.
I'm sorry they sent you to this hearing with so little information.
Well, I mean, I think if I had heard about impacts, I mean, if the department had heard about them, I would have heard about them to bring them forward today.
Okay. Madam Chair.
Thank you very much, Mr. Swanson. Ms. Houston, just a couple of questions. Can you tell me, under the new rules, what will be the length of time to obtain approval for a new provider from the time they come in and ask the county for approval to the time they actually get approved and can be on the job?
Well, it's my understanding that it's about a 4 to 6 week process before a provider would get paid in the old system, under last week's process. A recipient comes in, they're a new IHSS recipient or they come in asking for a new provider, and then they start that process of application, and then their provider has to get involved and do the provider agreement and the provider enrollment.
So how long will that process take now?
About 4 to 6 weeks is my understanding.
I'm sorry, I misunderstood then. I thought you said the old process was 4 to 6 weeks.
Oh, well, the new process, the DOJ process, the adding of the DOJ activity should be fairly quick. I mean, DOJ turns around the criminal background check requests if the background is clear in a couple days.
I'm talking about the new process under the new rules versus the old process under the old rules. And I thought I understood you to say the old process under the old rules took 4 to 6 weeks.
That's true.
Okay, so now under the new rules that go into effect November 1, how long will that process take?
I believe we think it's the same amount of time, adding the criminal background check process, which is now mandatory. Some counties were doing that already. Some public authorities were requiring a DOJ criminal background check already.
Okay, so you still expect it to be in 4 to 6 weeks?
I believe
just
so,
okay.
yeah. I'll confirm that, but I believe that's still the case.
Okay.
Because things are happening, at the same time.
Okay.
While waiting for the DOJ background check, other things are going on, so.
And can you tell me the exact conflicts that Ms. Belcher and Mr. Wagner had that prevented their attendance here?
I didn't ask Secretary Belcher. I know that they're involved in the Olmsted Advisory Committee. I don't know if that's where they are today. I'm sorry, I don't know.
Don't know. Okay, I appreciate it. Any other questions? Go ahead.
Yeah, Madam Chair, I believe there is a representative who isn't just the legislative representative of the department in the audience, Mr. Carney. I don't know whether or not he has any of the information that you haven't been sent here with, and I certainly would have appreciated if he'd been sitting next to you. Again, not to diminish your importance, but
I think we also have the spokeswoman for John Wagner here as well. Ms. Lopez, did you have anything to add? Thank you. Hi, Mr. Carney, welcome.
Good morning, Madam Chair. Scott Carney, Associate Secretary, Office of Legislative Affairs for the California Health and Human Services Agency. Assemblyman, nice to see you again.
likewise.
Did you have anything that you could add to enlighten us on the questions that we've been asking?
I would be happy to provide some more information. A lot of the implementation issues have been addressed by Ms. Houston. I think in regard to your last question, the Olmsted Advisory Committee is scheduled for today. That is something we notified staff of immediately after the last hearing, so that is where the Secretary is this morning, and we called that issue out. In terms of the implementation issue, I think the way we have been looking at this is that under the old process, it would take approximately 6 weeks from the time a new provider walked in and received their first paycheck. We anticipate that when the system is up and running and fully operational, it'll take about the same amount of time. So under the old system, prior to any change in law, somebody who walked in as a new provider on Monday would not be set up to receive their first paycheck by today. There would be a process for enrollment. We are working diligently with the counties. We are under truncated timeframes, and we don't have the luxury of the typical stakeholder process. I know that our colleagues at the Department of Social Services, they are very committed to doing that, and we remain committed to working with the counties. I was talking with our county partners this morning about what are some next steps about resolving this and actually moving forward on issues. I think that there are some significant differences and information, and a lot of it is due to the confusion, and part of that confusion is simply due to the magnitude of changes, and I don't mean to understate the magnitude of the changes. In regards to what we know today, our latest information from the Department of Justice is that 42 counties have already established relationships with the Department of Justice. We have information from EDS, who is the provider that manages the CMIP system, that in the first day of operation, there were already 160 providers that were moving forward with enrollment in the new system. So as we've looked at this, the department has done an incredible amount of work. They have worked the best they can to meet the deadlines, and they're moving forward as quickly as possible and trying to be responsive to the feedback that they're getting. I think based on the information that we have seen, that the presumption that there is somebody who is not getting paid today and that the sky is falling based on what we're seeing may be overstated. We don't mean to discount that we need to continue to provide clarity and continue to work with our counties to improve operations, but we are seeing that implementation is moving forward.
Are you able to provide the recipient or the provider any assurance as of today? We didn't expect to get a paycheck today, but are you able to provide them with the assurance that if they're working today, that they will, assuming they are cleared through the background check process, that they can be paid?
The department, and I would defer to Ms. Houston in terms of the specific implementation issues, but the department has issued all of its instructions. We continue to work with our county partners on providing the necessary clarification, and we trust and would be very interested in working with our county public authority and labor partners to make sure that we manage issues for the recipients, who are the most important folks in this whole.
So the question for the recipient, though, is, and they're trying to recruit a provider, can they tell that provider, or will the county tell that, or the public authority tell that provider, yes, you will get paid? Because otherwise, that person, they essentially would be asking them to volunteer on the at the risk that they might not be paid during the interim time period.
Understood.
And that's the confusion and fear that we're talking about here in terms of.
Absolutely understood, sir. The final instructions have been implemented. The automated system changes have been made, and they have been validated. And based on automation of those changes, and based on the fact that new providers are showing up in that system, we believe that that is operational and moving forward. Part of it, and I would need to get back to our program people who have the direct working relationship with the counties, part of it is dependent on how things are happening at the local level. I don't have that information on all 58. We appreciate that we need to continue working and providing clarification, and we're doing that. But the other part of it is that we have to work with and through our local partners. So the changes are there, and they will be in place, and it will happen.
But getting back to my question, the recipient and or the provider cannot be assured today, correct me if I'm wrong, that in fact if they go to work today, that in fact once they're cleared that they can be paid.
It is contingent upon the provider completing their enrollment process.
That's right. It's contingent on the completion of the enrollment process, which includes the criminal background check clearance. But I think the instructions are clear that if that happens, the provider can get paid retroactively.
So just following up on that a little bit, I've been hearing repeatedly this morning that DSS is still working and still working really hard to implement these new rules. So that's the problem. That's why we're here. I need to know, what does DSS still have to do? What kind of direction still needs to give to the counties? Because the counties still have their role in this, and they have to figure out what resources they need, how to get those in place, and how to actually implement the direction that DSS is giving them. And I mean, that is where we're trying to focus the purpose of this hearing. What is DSS still doing?
It's my understanding that all the ACLs have been issued. The county fiscal letter was issued last week about funding for counties to do the activities. Clarifications continue to be rolled out. This electronic bulletin board that I was talking about earlier, that you'll see on the list of things that have been released, those are very quick and easy to post for the people who are actually signing providers up. 2 of those have already been posted this week to provide clarity based on questions that came in.
Okay. Let's see. Any other questions, Mr. Swanson?
Just a very brief question. The department will, when they're in a situation like this, my question is, and you recognize that legislative action has been taken, is there any responsibility the department feels to help us by communicating back? You know, you did this, but you might want to consider cleanup legislation to address this question this way or that way. Has that kind of discussion taken place, or can we expect that kind of discussion, or do you sort of just go straight ahead even if the wrong things have been done here?
Well, we have in our letter it talks about the list of crimes to be clarified, and we know that statutory changes will be needed to make that change. It's not a policy change that we can just decide on our own. It requires statute. There may be other parts of cleanup as well.
Yeah, I was just wondering whether or not we're going to sort of be working together to try to identify some clear problem areas. When legislation is passed, the unintended consequences, will appear, and the question is, can we expect that kind of communication to the chair so that we can move quickly? I mean, maybe it has to go through the administration, and that's the way it comes. But you understand what my question is?
Absolutely, Mr. Swanson. And I think I would reiterate what Ms. Houston said, which is the administration, and alluding to some of your earlier comments about how are these conversations had. The department looks at these issues, and we talk about them within the administration. And the administration, not just the department, has proposed changes.
Okay.
And we do our best to identify those issues and bring them forward.
Okay. Thank you.
Okay, I think that's it for now. And
one more question.
Oh, sorry, Mr. Chesbrough.
And on page 3 of the letter which we were provided with today from the department, it states that as of midday, November 2nd, 3 new approved providers had been identified, had been approved, and 156 were pending. Do you have the updated status, and how many of the 156 providers have been approved?
I don't have it, but I can get that for you. We should be able to get that very quickly.
Okay, thank you.
Okay, I do want to note, though, on the issue of the Olmsted Advisory Committee meeting, I understand that started at 10, and the reason we scheduled this meeting at 9, despite the fact that the legislature worked all night long the night before, is that we wanted to allow the advocates to go to the 10 a.m. meeting, and we also wanted to have the presence of the director and the secretary, understanding that they had that conflict at 10. So we did try to work around that, and as I said, I would have been very happy to work with their schedules in other ways as well. So at this point, I'm going to ask Mr. Mecca to come up. If you two would stay there so you can provide responses to questions as we go forward, I'd really appreciate that. Mr. Mecca, you can move one of those name plates aside and take your place.
Thank you, Madam Chair and members. I'm Frank Mecca, the Executive Director of the County Welfare Directors Association, and I'd first like to thank you, Madam Chair, for your support, your authorship of your SB 69, and I'd like to thank the members here and the Republican members who couldn't make it for their unanimous support for that legislation. The last time we testified, we were very worried that we would be unable to enroll providers and that consumers would be hurt. And unfortunately, I'm here to say that what we feared is happening. And we have providers and caregivers who are unable to enroll and consumers that are hurting because of it. Before getting into my testimony, I'd like to say that the County Welfare Directors Association has neither the interest nor the luxury of excess energy to create issues that don't exist. These issues are real. Our members are calling about them every day. The suggestion that our interest in this issue is tantamount to a Chicken Little syndrome or sky is falling is not accurate. And I would suggest that anyone who believes such should talk to a county IHSS manager about how things are working. Madam Chair, you pointed out one consumer case. I'd like to just very briefly talk about 2 more that we've heard about from our members. In San Bernardino County, a 68-year-old former investigative reporter who'd been given 8 weeks to live 2 years ago, still alive, in her estimation, due to the care she's received by the IHSS program. Her condition is caused by arthritis medication that she used in the past that's caused severe liver damage, which has caused her body to retain water, which she can retain in excess of 50 pounds of water in a matter of days. Without the assistance of her caregivers, her lungs fill up with water and it impedes her ability to breathe. Her providers help her with taking medication, cleaning, cooking, and visiting her physicians. The recipient recently experienced a need for a new provider. The county recently was told the recipient that her new provider would not be able to care for her because the county was unable to enroll new providers, given that the counties didn't have the necessary directions to adequately set up the process. The woman now is going without part of her services and fears hospitalization or long-term care. In San Benito County, an elderly woman who recently had hip replacement surgery was scheduled to be released from the hospital on Sunday. In fact, we got a call from a discharge planner, as we often do, for people leaving the hospital. Because we've not been able to secure a provider for her because of the new rules, the hospital will not release her, and I think it's a shame for her, but it's also a drain to the general fund because that Medi-Cal is paying for that woman's hospitalization. These are just two examples of real cases. There are more, and we fear that there will be more over the next several weeks. I think it's important also to point out that this problem was created by what is, in my experience, an unprecedented decision on the part of the administration to basically turn off the prior law for enrolling providers before they knew we were able to implement the new provisions. I've represented the county welfare departments for 18 years. We cannot, and I cannot remember a case where an ambitious implementation deadline could not be met, where the administration said we're working in good faith with our partners to get it implemented, but because of a legislative deadline, we have to stop the prior law, even when we know it's to the detriment of consumers. It was that decision that created this problem. Many of these implementation issues are, in fact, I think, inevitable given the complexity of these changes. I think we concur with the administration in that regard. It's just we've never had a situation where we've been forced to create a trapdoor for people to fall through. And had we been able to continue the prior provider enrollment processes while we resolved many of these issues, we would not be here today. We wouldn't have needed to try for a legislative resolution. And I would also say that this principle of the immutable deadline is novel because we've sponsored bills, we've implemented your changes, hundreds of times, if not thousands of times. And we work in very good faith with the administration, always in a collaborative stakeholder process to implement as quickly as we can. But I think the record is littered with many instances, including the extension of the deadline to implement the FI cuts, where when faced with serious jeopardy, the deadline slips and everyone works in good faith and in full notification of the legislature that we're doing everything to implement. In this case, none of the normal processes, none of the normal engagement took place, and this notion that the immutable deadline is the cause of all is novel and unprecedented in our experience. Just briefly, we do have a handout with some information just to illustrate the continued concerns that we have. The first document in our handout, and I will not go through all 49 outstanding questions or issues that we believe exist, 48, I can't remember, it might be 49, with respect to the instructions for implementing the provider enrollment process. The first thing I'd like to point out is that there are still a large volume of outstanding issues. The first 2 pages outline 12 issues just with the criminal background check process, including the CORI clearance. And I'd like to clarify something. We cannot identify how the administration believes that 42 counties have the relationship with the Department of Justice to receive information. That's not what the counties are telling us. It's not what the counties believe. But I think what might be going on is there's a lot of misinformation, perhaps even at the DOJ level, sort of depending on which staffer you talk to. I heard this morning that a public authority director that runs a public authority for 3 northern counties was told today they have to have a staff member in each county to receive the information. So that that public authority has a relationship, or even if they had a relationship with the Department of Justice, they had one staff member in the public authority that serves 3 different counties. Now they need to identify staff in 2 other counties. That was information they got today. Last week, we had a county call the Department of Justice, and the staff at the Department of Justice told them that even though you have an existing relationship, you need to create a new one. In some instances, the relationship is with a public authority, but the county is administering this requirement, not the public authority, and the contractual relationship between the two needs to be executed. So a lot of outstanding questions on the criminal background check. I think it's interesting that in the information that you were provided by the administration, there were numerous instances to subsequent all-county letters that would provide additional clarification. We're implementing now, and so the somewhat, in our opinion, cavalier reference to the fact that we'll clarify some things in the future doesn't help when we're implementing the law now. This is not just an inconvenience for counties. We think it creates a liability issue, and let me take the example of retro pay. Will people get retro pay? We can tell clients now, based on information that we received on November 3rd, assuming it's legal, and I'll get to that in a moment, that you can be paid retroactively if you're cleared. But we can't tell them all of the rules and all of the standards by which they can know if they're clearable or not. For example, there are issues about the list of crimes that you've heard a lot about. There's a list at the Department of Health Care Services that we have to consult, the suspended and ineligible list. We've raised a host of questions about how to do so. We've been told you'll get information in subsequent all-county letters. So if a provider, based on what we tell them, works in good faith, thinking that they're clearable, and then for some reason they're not cleared based on a rule that we haven't yet been able to identify to them, what liability do we have for clearing, for giving information that turned out to be inadequate for that person? So it's one thing to say we'll pay you retro if you're cleared. It's another thing to say that we can tell you all the rules that you're going to have to, or all the standards that you're going to have to meet if you're going to be clearable. With respect to an issue that came up at the last hearing on translations, the orientation material and 4 handouts for clients continues to be only in English. 16 different forms that have been modified are still only in English, and the administration's position is that the counties have to provide translation assistance, which is both burdensome and impossible for many counties. There are still inconsistencies in the instructions as they are provided to us and recipients. For example, the CD that we give to people for orientation says that if you've committed a crime, you'll be barred for 10 years. From providing IHSS. All the other material that we've been provided says you're permanently barred. So we're giving clients inconsistent information. The orientation material hasn't been clarified. There's still work that hasn't been done. You created in legislation an option for indigency for providers who cannot afford the fee, the criminal background check fee. We're implementing the new rules, but we've not provided the instructions on how to establish indigency. So an important provision, given this is an expensive criminal background check for very low-wage workers, hasn't been completed. From my member standpoint, there's still a large body of things that aren't clear. And for 58 counties to sort of do their best on something that's so important, where the consequences for consumers is grave, but the potential for legal action and liability is so great, sort of do your best, read between the lines, use good judgment, really creates liability for the counties and the state, in addition to confusion and chaos for consumers and providers. The next handout I would like to draw your attention to is a timeline that I think graphically illustrates really the operational dilemma that counties find themselves in. What you'll see is that in the state's response to the committee, our interpretation of that is the implication that the counties have really known that this has been out there for a long time. The rules aren't new. We've been talking about this for a while, and I think it's important to really look at the timeline for implementation to illustrate why we believe we're in such a dilemma. The trailer bill was signed on July 28th. The first all-county letter regarding just the provider enrollment form wasn't provided until October 1st. On October 5th, DSS sent that informing notice that created such confusion and chaos in our offices. And just jumping to the end of this timeline, you can see that on November 1st, the new process was to take effect, but between October 29th and October 31st, that's when all of the instructions were finalized. Now, I'd like to just suspending disbelief for a moment and assuming that all the instructions were clear and adequate. And we clearly believe, based on our prior testimony, that they're not. We got basically the bulk of the instructions a day before we're to implement. And in the case of the EBB that I'm going to talk about, we got it 3 days after implementation. And so essentially what you see here is that the state got 3 months to draft and issue the instructions, and we got arguably negative 2 days to implement them. Now, receiving the instructions is one thing, but being able to hire staff, establish your county training, establish your procedures, identify space, put your contracts in place, get your relationship with the Department of Justice, we've been provided literally no time, lead time, to do so. That's unprecedented as well. That is not a situation that the administration or that the Department of Social Services has really put us in before. It's just not our standard operating procedure with our partners. And I would submit that the folks implementing the instructions should need at least the amount of time as the folks writing the instructions. But essentially, we got nothing. The next handout is a microcosm of an issue that you've been talking about a lot, and that is, can we pay current providers? And this is a chart that starts with the October 1st instruction, and I'd like to go through the history of the instructions that we've received on the clearing of current providers. On October 1st, the state issued ACL 0952 that said that current providers may be eligible for retroactive pay for services they provide if they complete the form. First of all, it says may. It doesn't say that they will. Secondly, it implies that all current providers will not get paid in the meantime, because it says current providers are eligible for retro. The implication is you're not eligible for non-retro. You're not eligible for prospective pay. Then on October 5th, the all-county informing notice that you've heard a lot about went out. And part of that notice says, and I quote, any person who provides services to an IHSS recipient must complete the steps outlined below before she can continue to receive payment. Clearly that says anybody. We're talking about the entire body of people who provide services. There's no distinction made in that notice between current or prospective. On October 6th, the EBB message went from the state's IT vendor to counties, saying that effective November 1st, all new providers will be subject to the existing provider enrollment requirements. This includes existing providers who decide to provide services to a new or different recipient. Now, this is important because this policy changes later, a couple weeks later. But clearly, as of October 6th, it's clear that if you're an existing approved provider and you provide care for a new consumer, you cannot be paid. That's on October 6th. On October 8th, we got a draft of the all-county letter for CMIPS changes that reiterates the October 6th EBB when it says, when a current provider elects to provide services to another recipient, they will have to complete the new provider enrollment process prior to payment being allowed on the additional case. Then it wasn't until October 29th that CMIPS instructions came out that were sort of confusing. It says that current providers currently providing services to existing recipients can continue to be paid. That's new. If you're a current provider for an existing recipient, you can be paid. But what isn't clear on October 29th is what if you're a current provider for a different consumer What if you're a currently approved provider for a different consumer? And it's not until November 3rd in an EBB that it says, please note, a policy decision was made to allow providers existing in CMIPS prior to 11/1/2009 to begin work for a new recipient under the rule to complete new work enrollment by June 2010. Later that afternoon, the actual computer programming change was informed to us. 2 days after the implementation date, we were informed through an electronic bulletin from a computer vendor to CMIPS users of a pretty important policy change that it would have been good to know earlier. Now, we're pleased with the policy. It helps, and I want to be crystal clear about that. But I think it's clear just from this issue that the process has been very confused, very chaotic. The instructions have been unclear, and they've changed over time. And again, a lot of that is inevitable when you're implementing complicated policy. But because of that, we shouldn't have turned off the old provider enrollment process, provider enrollment process in the meantime. I could not regret more being in this position because the contentious nature of the dialogue, the difficult strain on what is typically a very strong partnership, and the incredibly difficult position my members find themselves in every day facing consumers and providers, providers who want to work doing very important work and consumers who need that desperately to stay safely in their homes, is most regrettable. We've not enjoyed one moment of it. But the bottom line from my members is there are a lot of things that we have to continue to work on, and we have to continue to work on expeditiously to resolve. We're not close to having all the rules and infrastructure in place to implement this efficiently and effectively in a way that the legislature deserves. If we could continue the prior process while we figure these out, it would make an extraordinary difference. But absent that, we've got to work at lightning pace to try to prevent what will inevitably be more consumers falling through the cracks.
Thank you, Mr. Mecca. Questions from the members? A comment. I really appreciate your giving us the timelines. It gives us a visual idea of how things have happened, and there's been so much. It's been difficult to get, at least for me, a grasp on when these things happened and when they didn't. Mr. Swanson.
Yes, thank you, Madam Chair. I hope that the stories, the impacts are being well documented by the counties, because unfortunately, I think that we're going to be faced with another debate around the question of these services, how vital they are, and what budget cuts in this budget cut environment, whether it's a good idea to look at these programs. And so, so my hope is that the counties can help us in evaluating. It's my theory that these cuts cost us more in the long run than save us money. And I think that the example that you offered and the example that the chair offered, one example there, and there are just critical programs in the state that that provide us with so many benefits that we take them for granted. And so my hope is that the counties will help us document the impacts so that as we approach next year, we'll be able to use those examples in our arguments.
Thank you. I'm going to allow the department a couple of minutes to make a response, if you'd like to respond to any of the issues that have been raised. And then we've got a consumer that's going to be on the telephone. We're accommodating her inability to come to the hearing room. Would you like to take a couple minutes?
Thank you, Madam Chair. We are very interested in continuing our relationship with our county partners who are on the front lines. We received the most recent list of issues this morning. Patty and I will be sure to take that back to the program folks who are working on this, and we would very much like to work through those specific issues with the counties. And we'll make that commitment to do that. Again, I think, as you heard last week, that there is a statutory construct that the department is operating under. We would like to do our best to make that work as smoothly as we can for everyone, and we would like to absolutely focus on resolving issues for those people who are experiencing difficulties. I think, as you pointed out last week, that's absolutely an appropriate, detailed conversation for the department and our program staff to have with the counties, and we will commit to doing that. As I said, and Mr. Mecca and I had this conversation before the hearing started, that there is a difference in the information, the evidence we have. As I said earlier, we are seeing providers that are being enrolled, and it looks like the system is up and running. We should sit down and have that conversation and reconcile the facts. And that's something that is, as you pointed out last week, is most appropriate for our program folks who are working on these issues and monitoring to sit down and discuss with their county partners, and that'll happen.
Good. I appreciate that, and I appreciate the expression of cooperation. I appreciate it very much, and so I will expect those conversations to take place. As I said earlier, of course, the issue is the confusion and the chaos in the meantime, as the ostensible author of the bills, I want to make sure that they are implemented in such a way as to minimize that confusion and that chaos. So I appreciate your continued working on this, and I appreciate your coming here today and testifying. So we'll go ahead and excuse you now, and then we'll bring in Maggie D., who should be on the telephone now to testify, I hope. This is the first time we've done this, new technology, so hopefully it will work smoothly. Do we have her?
Thank you.
Hi, Ms. D.
Hi, yes.
Hi, this is Assemblymember Noreen Evans. I'm the chair of the Budget Committee. We appreciate your connecting with us by phone to give us your testimony. And so if you would, we have your written statement, which I understand you're going to read over the phone. So if you would, just go ahead with your testimony, please.
Thank you. Good morning. Thank you for the opportunity to address your committee regarding the rushed radical changes to in-home supportive services program, and especially to testify by telephone. 2 years ago, I was diagnosed with stage 2 anal cancer. I had 35 treatments of radiation, sustaining severe burns, which had to be dressed daily. For 6 months, I was free of cancer. The cancer has returned. November 17th, I will have the anal tumor removed and given a colostomy, a major life change, and many more hours of home care needed for these major life changes, as I have dexterity issues. My IHSS provider of 17 years will resign her job the day I am admitted to hospital for surgery. Cindy is a person who is high-functioning, developmentally disabled, and began her work here in July of 1991 with a green card. At that time, she worked the full 283 hours, 7 days a week. Suddenly, our lives changed when I was diagnosed with MRSA, 22 weeks of intensive care of 44 infected boils. Cindy tended to my exploding boils as the entire pubic and rectal areas raged with highly contagious infection. Then a month later with cancer. We weathered both storms together. 2 years later, we faced an insurmountable end to our relationship, changes to the IHSS program. A letter arrived stating that as of November 1st, 2009, about a month ago, major changes will occur. The letter was utterly confusing and frightening. Cindy announced 3 weeks after the letter arrived, the day I enter the hospital, she will leave the job. Oh, my God. Filling the job will be a nightmare, even if I find someone who I can trust with the ostomy bag changes. A nightmare of smells and cleaning the ostomy bag, as Medi-Cal only permits the lowest cost single bag. It is a disgusting cleaning process. It is highly unlikely I will find someone who will be willing to undertake such a nasty job. To make matters more complicated, getting someone through the new process can take several months. according to the Department of Justice. I could be without an IHSS provider while we wait for the process to be completed. I called the Department of Justice, who said, quote, background checks can be turned around in 24 hours or up to several months, end quote. I looked into explicit details for the radio program I produce. I do not panic easily. However, fear of being left alone without help will endanger my life, while the state and county rush into implementing the IHSS program change requirements. I saw the first hope of life-sustaining home care when I was accepted into the federally funded nursing home waiver program, which gave me an additional 283 hours of home care. The number one requirement is a person must be registered in the IHSS program before submitting their name to the federally funded waiver program. That can take another several weeks. This option or choice to stay out of a nursing home is an at-risk of nursing home placement consumer. Was my assurance that I will never have to go into a nursing home. Choice between home care or nursing home care was my Valhalla. I became a waiver consumer and celebrated the day no more nursing home fear. The U.S. Supreme Court decision, Olmstead versus LC in 1990, was the first light at the end of a very long tunnel. I was to be permitted, one, choice where I wanted to receive my care in the least restrictive setting based on my individual abilities, not my diagnosis. Now I am at a higher risk of losing my independence each time I must replace my IHSS provider. The harm is irreparable. With this rush to start a program few counties are ready to implement. I would rather die. Trust me, I would rather die than be shut away in a warehouse for the dying called a nursing facility. My county is not ready to implement the new regulations. They do not have the staff or the funding in place. This further complicates my finding an IHSS provider prior to my surgery date of November 17. The best case scenario is hospitalization for 2 weeks. The worst case scenario is 2 months, my surgeon told me last week. I may become ventilator dependent. I have COPD and my list of multiple disabilities. People live independently in their own homes and use a ventilator. The end of December, I lose my second provider who has taken the LVN state board. I am devastated and frightened. I implore you to consider those of us who are severely disabled to rectify the speed at which all stakeholders are being rushed into program changes that will be detrimental to tens of thousands of us. Time is my enemy, as it is for countless people on the in-home supportive services program. I do want to participate as part of the solution, not as part of the problem. In my 26 years as an advocate and a past grateful recipient of the prestigious award, the State Assembly Woman of the Year, I want to participate in public hearings to enhance rather than devastate people's lives who count on our state home care program. Panic is evident in the world of consumers and providers. Thank you again for the opportunity to address the committee. My life is in your hands. Thanks.
Thank you so much for your testimony. Could you tell us what county you live in?
I beg your pardon?
What county do you live in?
Contra Costa.
Contra Costa County. Okay, thanks so much for your testimony. We're going to...
Thank you for the opportunity.
Thanks a lot.
Bye-bye.
Bye. Okay, next we have Deborah Doctor, Disability Rights California, and you'll be our last witness.
I should have probably said this while she was on the phone, but that certainly her testimony crystallizes the issue very effectively and personalizes it, because it's real easy at the state level to see this as a bunch of numbers and start talking about, well, how many people this, how many people that. These are individuals, vulnerable individuals living in all of our communities, and I think she represented that very well.
Well said. Ms. Doctor, go ahead.
Thank you, Madam Chair and members, for allowing me to speak again and for accommodating Maggie D. Nobody could say it as well as she did. I'm speaking on behalf of people with disabilities, including seniors who depend on IHSS, and make a few points about how the implementation process is affecting consumers. And the first way is kind of abstract, and that's in our relationship with DSS. We've worked with DSS staff in the past on various efforts. We've worked in good faith. We may have disagreed, but we built relationships based on that good faith. We withstood some hard trials, or trials that I thought were hard up until the last couple of weeks. In those weeks, we've heard statements and seen statements made that have caused our relationship some fracture, I would say. We sent in comments on all the ACLs that we could. We got no response. We have no idea why our concerns were not addressed. And I acknowledge that DSS is representing the administration, which has been hostile to IHSS since it first came to office, always seeing it as a liability instead of the asset and treasure that I believe it to be. I hope we will be able to regain the working relationships we have had with the DSS staff. Again, as Assemblyman Chesbro said, the changes which the department is saying it can't make now, it absolutely did make on the functional index. And on August 20th, spokeswoman Lizelda Lopez said that the department had decided to delay those cuts because of concerns, quote, brought to the department's attention by a number of interested parties. She said, "We need more time to come up with instructions for counties." So this sounds familiar, and what it tells consumers is that it's not that these changes couldn't be delayed, that it's a choice that the administration has made not to. As has been mentioned, consumers have received one piece of mail about the provider enrollment changes early in October. And as we now know, that information is no longer correct. But consumers have no way to know that. They have only the first piece of paper they got, which said there's no back payment if you hire somebody who's not gone through the system. Just in the last couple of days, I found out that the definition of existing provider is someone who's been on the system, CMIPS, anytime since January 2001. Now, I've been barely able to follow these changes, and I worked in IHSS for a long time. So no consumer knows that. And these are the people who are expected to act rationally and, obey all the rules, but they don't know any of this. The rushed imposition of the provider enrollment changes that consumers cannot enroll new providers when they need them, period. On a practical level, this has the same effect as denying services to somebody who's not eligible. But the difference is these folks are eligible. They're not tainted by any whiff of fraud. They just have made the mistake of needing services at the wrong time. Here's a message from one of them. She lives in Santa Monica. She said, "I am in need of serious surgery. I will need to be requesting paramedical services in addition to the hours I have now. It may take 2 providers to cover these hours. I need to schedule surgery, but am afraid to do so because of the present problem with provider enrollment and need to hire new providers to cover my needs. I am very frightened." Now, in the letter that DSS sent concerning SB 69, it said that, quote, "Recipients can work with their county social worker and public authority to find another existing provider or find a provider from the registry, just as they would if their provider was ill." That seemed to me to be a rather breezy assurance that doesn't match the reality of the capacity of the county social workers or how the registry works or the lives of consumers. The providers on the registry are subject to the same requirements as every other IHSS provider. They haven't been given some dispensation from meeting the requirements. But most importantly, providers and consumers are not tube socks. One size does not fit all. Here's the reality from the words of Nancy Becker Kennedy of Los Angeles. "I am quadriplegic due to a diving accident that happened 38 years ago. First of all, I must tell you I am so hurt that I am being treated as if I am a criminal and that my 3 workers who are dedicated, compassionate, and work hard at work that, believe me, you would not want to do are being treated this way. If I have to hire another worker after November 1st, I don't know how I'm going to be able to find someone with these new requirements. I hate to share this with anybody because it's very embarrassing, but the fact of the matter is my caregivers spend close to 1 hour in the morning evacuating my bowels on a paper diaper. Then they have to heavily assist me getting into my shower chair and wheelchair. I sometimes have 2 providers quit before a third one lasts on the job because the work is just distasteful and extremely difficult, and some people can't handle it. How is this going to work with the requirement of these low-income people coming up with $70 for criminal background check? If a caregiver leaves me without notice, as happened once, who will pay for the new caregiver while the results of the criminal background check come back? I am really quite terrified that after the November 1 laws go into effect, I will not be able to find a relief or perhaps even primary worker. I must beseech you to please understand the nature of the laws you are making. When our county welfare directors who are in the field and understand how the program works tell you that these changes will cause tremendous suffering, please listen to them. I am beseeching you to solve these problems so I can continue my decent life in my own home and helping others at the Hollywood Sunset Free Clinic, rather than be sent to a nursing home for more than 4 times the cost to the taxpayers of California, and the difference between a life I'd want to live and a life I'd want to die before. Thank you.
Thank you very much. Any questions on behalf of the members? No. Thank you very much for your testimony, Ms. Doctor. All right, that's all the witnesses we have today. Any closing comments? Mr. Chesbrough.
I know that the policy is in law now, so that's not what the hearing's about, but I thought Ms. Doctor's comment about treating providers, much less recipients, as criminals was appropriate. You know, if you spend some time talking to providers, and I have, and you realize how many of them are really the Mother Teresas of the world. They're these dedicated folks who are obviously not doing it for the money because we don't pay them enough to make anybody want to do that job for the money. They're people who, in many cases, have been with their recipient for many, many years. And it's just deeply troubling that rather than seeing this service as important not only to the individual freedoms and rights of the recipient, but also important to our entire society by way of fully recognizing the civil rights and of individuals regardless of their ability or disability, but also from the taxpayer's standpoint. And the idea that somehow or other this administration has viewed the recipients and the providers as a problem for the people of California rather than the solution is horrific, in my opinion. And this insistence on moving forward in a rigid way when in fact counties are not prepared to do this and effectively is just caps off a really terrible decision that the governor, I think, forced the legislature to make in order to keep the state solvent as part of the difficult budget processes that we have been through. So I just wanted to make that comment, Madam Chair.
Mr. Swanson?
Yes, I continue to believe that this is a bad policy, that in fact it should be a policy that is revisited. I think that some of the stories that we hear point out that this is not your usual line item in a budget. All cuts in the budget have impacts. These cuts have multiple impacts. And I think that any fair analysis will show that these impacts, in fact, undercut the original intent of the policy, and that is to save the state money. I do not believe it does. And I think that a case can be made. And I hope that the advocates in the independent living community, as well as the counties, help to make that case. because I just think that there are services that we provide in this state that should not be compromised and that should be not undervalued but fairly assessed, evaluated properly, so that we're not just moving ahead blindly with policy changes that have these kind of severe, life-changing adverse impacts. So I'm hopeful that, of course, we will smooth out the implementation of this legislation in a very humane way. But I believe that this policy is wrong, and that the legislature should revisit it.
Thank you. I would also add that this policy is a perfect example of why policy should not be made in Big Five negotiations. It came out of the Big Five negotiations. It was not heard in conference committee. It did not go through the usual legislative process. There were no public hearings on the policy. There was no ability of the legislature to influence the outcome of the policy. There was no public input on the policy, and there was no input by the stakeholders, and there was no stakeholder process prior to the adoption of the policy. So it's a perfect example of why we should not be using the Big Five to make policy changes. I would also just add a few things, since my name is associated with the bill. I want to be real clear on the record. It was not the legislative intent to create an immutable deadline that cut people off of their services, nor was it the legislative intent at any time to create a system that squeezed providers, thereby denying eligible recipients the benefits to which they are entitled under law. This is an entitlement program, and I fully recognize that it is a tactic to squeeze the availability of the services and thereby cut the services and thereby cut the costs. I know that that is a common tactic. The legislature will not allow that to happen in this instance. It was never our intent to do that, and I think that perhaps the unintended consequence of the chaos that has been resulting from the poor implementation of the new policy changes is that it will indirectly cut off these services, and I fear that. And the legislature will continue to do its oversight in this respect. I appreciate the comments from the department today indicating that they will continue working with and cooperating with the counties. But in the meantime, there is a great deal of human distress out there, as we've seen, caused by these changes. And it's my hope that we can continue to work to minimize those. And as I said earlier, I'm going to pursue every avenue available to me to both, as Mr. Swanson has suggested, revisit this policy when it's appropriate to do so, and to also make sure that we minimize the chaos and the distress that's resulting during this time. I appreciate everybody's participation and attendance here today, and we are adjourned.